Thank you everyone for your patience. So good afternoon and welcome to today's panel. We'll have the challenge of looking both at an in-person audience and switching to the screen so our virtual participants can see us. So bear with us if we're not making eye contact the whole time. But we're really glad to be here today for this panel. The panel is titled Leading the Charge, Women as Arbitrators, Damages Experts, and Counsel in Renewable Energy Disputes. I'd like to extend a warm welcome to all the participants here in the room and those joining us virtually. And it is a distinct pleasure to welcome you today. I'd also like to thank the organizing committee, Jose Antonio, Maria, Mohsen, Ian, for all of the hard work that went into the preparation of this event today. And one additional thing of note is that this is our fifth year in a row putting on this panel. It's a collaboration between Washington Arbitration Week and Arbitral Women, and I'm fortunate to be a executive board member of Arbitral Women. So we're really grateful to the organizers for continuing to keep this tradition alive, and very happy to be featuring, as we do each year, either an all-female panel or issues centered around featuring women practitioners and the challenges that we face from a gender diversity perspective. However, the substantive content of our panel is going to be, of course, very interesting, hopefully, for our panelists to hear about as well. So not only are we all women here, but we certainly have quite a bit to contribute, as you will see. So for those, just a quick word on Arbitral Women, for those not familiar, it is a globally recognized as the leading professional networking organization for the advancement of women and promotion of female practitioners in international dispute resolution. For over 30 years, Arbitral Women has promoted, supported, and celebrated women in ADR, and the network hails from over 40 countries around the world. We actually now have a new scheme in place which permits individuals from countries that may not have the same financial opportunities to join at a rate that creates, removes barriers to access and creates more facility for individuals to participate in the many services that the organization offers. So I invite you all to learn more about it. I'll also put in a quick plug for the ERE pledge, which is the equal representation, the sister organization of the Equal Representation and Arbitrators, pledge, which is focused on increasing greater diversity amongst arbitrators and female practitioners. The sister organization focuses on similar issues, but with respect to expert witnesses. So a number of our panelists here are involved with that initiative as well. So I encourage all attendees to have a look at those two initiatives, which are doing a lot of fantastic work. So let me proceed now with introducing our distinguished panel of women in roles which intersect with renewable energy disputes. And although each of these women has quite an extensive CV, I will just briefly introduce their main credentials. So I'll start on the very left. Julie Carey is a senior managing director at NERA Economic Consulting. She's a deeply experienced energy economist with decades of experience analyzing the energy sector. She routinely provides expert evidence in international arbitration, both commercial and investor state, as well as in other regulatory and commercial venues. And her work includes energy market, regulation, damages, and valuation analyses. Since 2016, she's also served as adjunct professor at Georgetown University, where she teaches a graduate level course in energy economics and policy. Rebecca Velez, I'll skip Alayna quickly and come back to you. Rebecca is a partner at HKA, our host today, so thank you so much for hosting us and to all the staff that are assisting. In DC, with over 20 years of experience calculating damages for litigation, arbitration, and other complex business disputes. During the past 15 years, she has focused more on international arbitrations, particularly investor state disputes. She has been part of the damages team on over 40 arbitrations across varying industries, with a high concentration in energy and mining matters. And Rebecca has prepared damages analyses based on business or project valuations, lost profits, invested costs, amongst other methodologies under various arbitration rules, including ICSID, ICC, UNCITRAL, PCA, and Energy Charter. She has testified several times in both English and Spanish, and she is on the Global Steering Committee for the ERE Equal Representation for Expert Witnesses pledge. Going back now to Alayna Tria is a director with BRG's Energy and Climate Practice. She has over 15 years of experience, including a decade providing valuation and damages quantification for international energy arbitration. She has managed the preparation of expert analysis and reporting for 30 international arbitration and litigation cases. Involving the calculation of damages, as well as industry opinions on energy prices, markets, and commercial standards. Ms. Tria specializes in energy asset valuation, commercial, economic, and financial analysis of energy purchase and sale agreements, and renewable energy investments, market forecasting and pricing, supply chain economics, and causation analysis for breach of contract and issues of force majeure. She is also on the Global Steering Committee for the ERE pledge. And last but certainly not least, Clara Brillembourg is the program director for legal strategies at Sequoia Climate Foundation, where she leads the strategy for investing in global legal initiatives to drive climate change mitigation. For nearly 20 years before joining Sequoia, Clara specialized in international arbitration and litigation as a partner at Foty LLP. At Foty, she counseled sovereign states in international treaty disputes against other states, foreign investors, and U.S. plaintiffs, as well as companies in international treaty disputes, particularly involving environmental protection, human rights, and public health. So you have quite a distinguished panel here today whose work intersects quite a bit with our theme of renewable energy disputes and climate change issues. So let's dive right in with Clara, who's going to give us a very helpful overview of the climate legal action landscape around the world and what are the key issues that we're currently facing.
Thank you. So in 10 minutes, I will try to context set by talking about three things, starting from a broad level and then zooming into what brings us here today, ICS and climate and renewable energy in particular. So these three things are first, the larger context, the state of climate action and renewable energy in the world today. Second, the legal context within that, highlights of recent climate legal wins and what the state is of climate legal action. And then within that, of course, play the important role that ICS has and the context of how climate and renewable energy fit within the broader world of ICS. So if you live in the United States, and particularly in DC, as I think everyone here does, it is completely understandable to feel like climate change reform has ground to a halt. It is clearly under assault here. And we see that the climate and renewable energy agenda in the US has been, sadly, largely gutted, but not entirely gutted. And there is still much being vigorously challenged in US courts that hopefully will yield some good results. It has been to date. 85+% of challenges brought against some of the climate action taken by the administration has been successful to date. So there is hope. We also see that the US is also pushing its climate change agenda in not just here, but in the rest of the world. President Trump, of course, talked about the climate hoax in his UN speech, but he was the only one. We also see the US in its trade deals with the EU, Korea, and others, pushing them to agree to remarkable, if not impossible, levels of US oil and gas imports. So this is going to be playing out for the next 3 years, and we will see where it finally lands. But meanwhile, zooming out for the United States, the renewable energy sector is flourishing in other regions. Asia and China in particular have established itself as leaders in renewable energy. The fact is that renewables are now cheaper than fossil fuels if politics get out of the way. And that alone, put climate change aside, put environmental protection aside, pure economic interest should lead towards renewable energy. We've seen China in particular is currently the largest greenhouse gas emitter in the world, with accounting for 30% of GHG emissions. It is now also the largest producer and exporter of renewable energy. China has added more renewable energy generation than the rest of the world combined. In fact, China's clean energy exports alone, just that, will cut all global GHG emissions by 1%, the entire world. As a result, countries around the world are rapidly importing renewable energy and building infrastructure, including in South Asia, and in India and Pakistan in particular, Southeast Asia, Africa and Latin America. We are seeing a boom in renewable energy, basically in the rest of the world, putting the US and a kind of patchy EU aside, or not aside, but within that. What this means is that we're at a turning point. Renewable energy is cheaper than fossil fuel-based energy. This is huge. It is no longer about climate. It is about economics. If, again, we can get entrenched interests aside. In 2025, for the first time, wind and solar have generated more electricity than coal. In the first half of this year, solar met 83, just solar, not wind or any other renewable energy, solar alone met 83% of the global increase in electricity demand. So we're at a turning point where this marks the beginning of a shift, where clean power is keeping pace with demand growth. And today's news, I was excited to see the announcement this morning of the Nobel Peace Prize in Chemistry going to scientists who come up with a new form of molecular architecture that can capture climate emissions and air pollution. So with some doom and gloom and massive challenges on the horizon, there is also a lot of room for hope and for action. So stepping in, taking that larger context into consideration, where does legal fit within that? Where does legal action fit within that? As of this year, climate cases also have now reached a point of momentum where they are compounding and snowballing on landmark decisions from the last 5 years. Over 3,000 climate cases, and climate being a broad kind of category, have been filed in over 60 countries around the world. This year and last year, we saw the advisory opinions on climate from the ICJ, ITLOS, the Inter-American Court of Human Rights. One was just filed with the African Court. They have wildly exceeded everyone's expectations with unanimous, strong, and clear confirmation of state responsibility to meet and continually strengthen climate commitments for themselves and importantly for the companies that they regulate. We also had the great victory in the Cherine case against Switzerland before the EU Court of Human Rights, where for the first time an international human rights courts recognized inadequate climate action as a violation of human rights, setting precedent across all of Europe. That is a binding decision. The interpretation should affect all EU countries. We also saw remarkably a series of wins from separate courts in the UK, Norway, and another advisory opinion from the EU Trade Court on Scope 3 emissions, specifically confirming that downstream Scope 3 emissions must be considered in project approvals, building climate accountability into planning law and importantly into permitting. And lastly, just to highlight one more of the many cases I could highlight, was the important decision, the landmark recognition by the Korean Constitutional Court that climate action and inadequate climate action actually violates the constitutional rights to life and a healthy environment. And they then mandated that the Korean parliament go back and revise its climate targets with realistic action and policies to make that happen and ensure implementation. And that, of course, is a landmark decision that is affecting and kind of creating a ripple effect across all of Asia, with a lot more action in the works. So we just zoomed down. We started at the broad level. We zoomed in one more. So now we're zooming into ISDS. As we all know, there's been a rise in environmental and energy cases in investment arbitration and commercial arbitration over the last several years. Spain ranks third in the history of investment arbitration cases as the most frequent respondent in ISDS, in large part due to its reversal on its renewable energy policies. Doing a landscape review, and you can categorize it or bucket it in many different ways, and this is just the way I like to think about it. There are kind of four categories that climate ISDS cases fit within. One are cases relating to environmental permits and the denials of those permits. So Rockhopper v. Italy is a kind of perfect example where Rockhopper was denied its offshore permitting as a result of environmental and climate policies issued by Italy. They won in arbitration, so Rockhopper succeeded, but then there's a kind of win as the national courts then vacated that decision. The second bucket is cases relating to measures with climate objectives. So RWE versus the Netherlands is another good example where we saw the Netherlands issue, in line with its net zero commitments, a coal phase out policy. And we just heard that indeed renewable energies have now superseded coal. As a result of that policy, RWE and others sued the Netherlands in ISDS. The third category is cases relating to the modification or withdrawal of measures with climate objectives. So that goes back to the example of Spain and its reversal on its renewable energy policies and all of the resulting investment and commercial arbitration that came out of that. And a fourth kind of brand new category that I like to build in is cases relating to the absence of environmental protection. And here I highlight the case of Peter Allard versus Barbados. In that case, Allard brought claims that Barbados had failed to implement measures to adequately maintain and protect the wetlands on Barbados's coast, where the investor had built a nature sanctuary. So here we see someone using investment arbitration as a means, as a vehicle, not for pushing against pro-climate or pro-environmental, I should say, these weren't climate measures, but saying you weren't doing enough. And that might be an interesting new window and opportunity for ISDS to play a role in the climate agenda going forward. These cases reflect the two sides of the coin. They reflect the phase out of fossil fuels of the past and the phasing up of renewable energies of the future. And we're going to continue to see those two sides of the coin play out in ISDS. It also reflects the fact, and here obviously I am coming up at it from a certain perspective, that the fossil fuel industry is now the most prolific user of investment arbitration. So as a result of that, we have seen the system feeling the quakes from this earthquake. And there is an increasing call for reform throughout the system. Of course, we saw the mass sweeping of the Energy Charter Treaty withdrawals, where countries largely have exited that system because of a lot of these issues that have just been raised. We see the UNCITRAL Working Group 3 slowly and cautiously considering, how states' right to regulate should be better protected within the ISDS system. UNCTAD, IISD, and CSIS and others are proposing alternative options, positive alternatives to investment treaties to see, is there another new way forward? And there's also within that a growing movement for a plurilateral agreement between states to carve out or exempt fossil fuel or climate measures claims from BITs between those states, those signatory states. And finally, many men, perhaps some in this room, are providing advice for how states can safeguard climate measures and account for climate in existing and future treaties, as well as in their arbitrations. And here, among many things I could highlight, I do want to give a shout out to CL's toolkit that they've written as a way of, as a kind of guidebook on how to safeguard fossil fuel measures from investment treaty claims. So hopefully I was able to give a good survey in 10 minutes. Thank you.
Excellent. Yes, thank you so much. That was so very helpful to set the scene for what we'll be discussing. And, you know, as the other lawyer on the panel, maybe just add 2 words to say that you know, you focused primarily in your last part on ISDS, but equally on the commercial arbitration side, we've seen, you know, an extensive amount of claims as renewables issues, climate change issues tend to intersect increasingly with the commercial world in which, you know, businesses are operating. So we've seen ESG related claims, we've seen environmental due diligence, human rights due diligence claims that are slowly kind of creeping into the commercial world and then appearing in disputes. And of course, everything around green technology is projects related to renewables and then the building of renewable power plants and other such projects. So equally present on that side of things as well. So thank you so much for that very helpful background. So why don't we move now to our 3 experts now on the panel. We'll start with Julie, and I want to explore now you know, how now that we have an understanding of the legal framework in which we're operating, how do these issues come up either in an industry perspective with respect to kind of the industry norms and understanding of the kind of context in which these issues come up, and then of course in the valuation aspect of disputes. So with Julie, Julie, can you please explain to us when considering expectation of reasonable return of an investment, what are some of the growing challenges for both investors and states with the evolving and uncertain technology market impact and regulation around some of these new technologies?
Yeah, happy to answer that. And I think it does also apply to the commercial arbitrations as well. You know, you're entitled to legitimate expectations. Every case has a unique fact pattern. That's true regardless. But now we're into more, what I believe are more complicated energy regulatory market dynamics. We have very complicated regimes that are setting these regulatory incentives, whether it's allowing renewables and requiring more renewables to come into the market, or if it's surrounding setting a price, implicitly a price on carbon, less so in the US, but very common around the world. And these regimes are becoming even more complicated. The Spain examples, I think, are more black and white and simple, whereas based on my experience analyzing in detail renewable regimes, they are more complicated as a framework of a set of rules, and I'll call it a market design that can be more anticipated to evolve and change over time. So there's not a specific guarantee. And so there's incentives that are wrapped into being invited and able to invest. And so evaluating what are legitimate expectations in that circumstance has to consider the full regulatory regimes, the full array of benefits conveyed and narrowly focused, isolated, causally impacted, and there are layers. And so the regimes themselves are complicated. The technologies evolving are more complicated, right? So we've talked about renewable coming, you know, which came down the cost curve tremendously for solar and a little bit less so, but still true for some wind. But there's a lot of new kids on the block that are coming in terms of even, you know, hydrogen, batteries substantially. We're seeing more technology on the carbon abatement side, and lots of other, a much longer, more robust list of new possible solutions. I mean, I can't tell you, I started tracking all of the new technologies when I started teaching at Georgetown 10 years ago. And the amount of new technologies and potential winners tomorrow are the widest, most substantial, deep array. And that means there's more uncertainty as to who is going to show up in a long-term forecast that you have to demonstrate with reasonable certainty what legitimate expectations would have been and that impact all of these markets. So it gets complicated. And then these technologies are in ascent. Batteries, you know, I can debate as to what the efficiency decline curve will be over time. How will they perform? Are they going to be paired with solar? What are you expecting? What is the outcome of that? It gets complicated. It gets detailed in technology, and that's on the supply side when we have a wild swinging demand side with AI. You know, the forecasters of power have been wrong in ways that defy some logic. Sad to say, there's more of a traditional of how you forecast that wound its way in more from GDP and not understanding the technological component. But now we have swings from too low to likely too high. We don't know what technology will win the day. There are wide-ranging demand estimates of consumption from those technologies. And so who wins will have a difference. I mean, we can end up swinging too high on supply, more than people might think. That's not talked enough about. But moving pieces, moving pictures, all have to be captured in what are your legitimate expectations, what are the impacts associated with it, and how do you develop damages and valuation to reasonable certainty. And then lastly, in terms of project expectations, you know, unexpected developments, as we've talked about, intertwined into regimes and other impacts. There could be unrelated decisions of where you place something, you know, and you're negatively impacted. Is that separated out? You know, transmission grids are notoriously problematic. You know, if a wind power plant sites itself here, and then somebody else as a market participant got approval to site them next to it, and then they become the constraint and their power is not being taken, you know, was that a legitimate expectation? Raises real questions. And then overall, you know, by definition, if the project is being built, it has deemed itself profitable. There's a degree of self-fulfilling belief, over ambitious. We have past cycles where everyone took forecasts to say, I'm setting aside and ignoring market participants' other entries, and I estimate a robust price forecast, and I think I'll get that. Well, was that really a reasonable expectation? Is that a legitimate expectation? And those circumstances led to lots of bankruptcies. They led to oversupply. But now we're going to find the dynamic period that we're in, like no other. It's going to have challenges, and it will raise questions about, was your expectation to begin with reasonable and legitimate? So everything gets more complicated.
Thank you so much. That was a helpful introduction to that. Let's move now to Rebecca on the question of how environmental and regulatory shifts are impacting valuation of damages, particularly in renewable energy disputes. And if you could share some examples from your practice about where there's been an issue of technical complexity that has significantly influenced your damages analysis.
Okay, sure. So obviously both those shifts, environmental and regulatory, can significantly influence the valuation of damages. Regulatory changes can directly affect the profitability and even the entire viability of a renewable energy project. Some of the more common ones are like the withdrawal of subsidies, changes in feed-in tariffs, and the implementation of new compliance requirements. So when these shifts come around, a lot of times they lead to disputes when governments reverse or change the incentive schemes that they've had. So as has been mentioned, and I know will come up again, Spain, they rolled back all of their subsidies, and that triggered a lot of investor state claims. And new, more strict environmental standards can increase the operational costs of a project, or delay the project timelines, which then impact the projections and your expected returns. So tribunals need to determine whether these regulatory changes constitute a breach of the contract or the treaty. And with the input from the damages expert, determine how to quantify the resulting financial harm. From an environmental perspective, climate and ESG factors are coming up more and more, adding to the complexity of the disputes. So carbon credit disputes and compliance with net zero targets regarding greenhouse emissions can affect project valuations and lead to new forms of damages claims. And disputes also arise from whiplash policies, which is where governments backtrack on green commitments due to political or economic pressures. So there needs to be a balance between the investor's expectations, as Julie mentioned, and the state's sovereignty. So when investors make an investment in a foreign country, they do have an expectation of some regulatory stability and profitability for the project. But at the same time, the state does have the right to regulate, particularly if it's in the interest of the public, and especially when it relates to environmental protection and energy security. So again, the tribunal needs to make a decision and consider whether the investor's expectations were actually reasonable, and also whether the state's actions were appropriate and non-discriminatory, and were they or were they not a breach of the contract or bilateral investment treaty. As far as the technical complexity, before I share my examples, I'll talk about some of the complexities that come up. So really the first one is the selection of the valuation method, whether you use a DCF, fair market value method, or a sunk cost analysis. So the selection is based on the nature of the investment, the stage of the project, whether it's feasibility, construction, commissioning, operations, even decommissioning. Anywhere along the line, like claims can come up. And the timing affects the reliability of the projections that you use, and the timing of the actual loss. You also need to consider the availability of data. So are there historical financial statements you can rely on, or any type of historical operational data? Are there market comps? Also consider the specifics of the breach. Is it an expropriation versus a regulatory adjustment? The investor's expectations, which we've touched on a few times, are they legitimate and reasonable? And causation. We need to make sure that the loss was directly caused by the regulatory change. So we need to separate regulatory impacts from like tariff cuts and like permitting delays versus technical or operational issues, which are things like design flaws, underperformance, or cost overrun. So once you decide which methodology you want to use, then you need to ensure the accuracy of the valuation model that you're using. So in this step, a lot of times damages experts rely on input from engineers, technical consultants, or other industry experts to help validate assumptions that are very technical, such as the capacity factors, degradation rates, maintenance schedules, things like that. And these are all going to differ depending on the type of the project, whether it's a wind project, solar, hydro, whatever type of renewable project it is. And they each come with their own technical and engineering nuances that need to be considered. So the industry expert would be very helpful there, and they can also help a damages expert identify comparable projects if using the fair market value, and identifying relevant or irrelevant costs if using a cost approach. Other things that need to be considered are mediation and remediation costs. So did the investor take steps to mitigate their losses? So that can mean incurring some costs that otherwise wouldn't have been incurred, right? So you spend a little bit more here to bring the damages down on the other side. So that needs to be considered when determining damages. And the fact that all of these projects must comply with the technical and environmental standards that could be changing throughout the life of the project. So again, you need to separate whether the damages stem from the actual regulatory change, or does the damage stem from non-complying to one of the standards that has changed? So going on to the examples of cases that I have worked on, aside from all those technical complexities that I just mentioned, like other little things come up, of course, everyone is different. So Spain, I've worked on several of the Spanish renewable energy cases. So in 2 sentences, the background of it is that in the late 1990s, they implemented feed-in tariffs to attract investment in solar and wind energy in Spain. And then in the early 2010s, the government retroactively reduced those incentives due to budgetary restraints, and even implemented a 7% tax on certain revenues. So this would reduce the investors' return, right? So clearly the investors weren't happy. Multiple claims were filed under the ECT and bilateral investment treaties. And the investors were claiming that the regulatory rollback destroyed the economic basis of the investment. So in most cases, a discounted cash flow model was used to assess damages. So they compared the expected returns on the project under the original regime, which would be the but-for scenario, versus the revised one as the actual scenario. And so this was an example where, aside from all the financial and industry complexities that need to be considered when calculating damages, I had to work very closely with regulatory experts to provide insight on the changes and the interpretations of the regulations. And so the regulatory experts actually submitted an entirely separate report that then I had to rely on and incorporate into the damages calculation. And another example is a case in Peru that involved 6 hydroelectric power plants. The additional technical complexity on this one was determining what was the actual project that was being valued. So this was an interesting case where the tribunal's jurisdiction depended on the amount of damages that was being claimed. So typically damages come after jurisdiction, but here it was kind of all intertwined because there was a certain threshold of damages that had to be claimed for the tribunal to have jurisdiction. So of course, the claimant wanted the damages to surpass that threshold. So what they did was they treated all 6 plants as one project, even though they each had their own contracts with the state. The plants were all at different stages. Some of them were operational, some were not. They were on different timelines, completely different management teams, operational projections. Their construction was different, their infrastructure, how their energy was produced and delivered was different. So they were different in like every single aspect we could think of. So while I was able to say that from a financial perspective, these were multiple projects, I again had to work with industry experts and engineers to rely on them to help me differentiate the plans and like their very technical operational issues that would have them be considered different projects. So we were able to convince the tribunal that there were 6 different projects and not one, as the claimant was trying to present. And so the damages that we calculated were nowhere near the threshold that needed to be hit so that the tribunal could have jurisdiction. So the tribunal ruled no jurisdiction and awarded the state all of the costs for everything in that case. So that was a good outcome after a lot of work.
Thank you, very fascinating. Helpful segue into our next topic, which Alayna will treat, involving how the energy transition accelerating, and as disputes are evolving around complex interactions between technology, policy, and commercial expectations, how can experts best serve the tribunal in evaluating issues of causation in particular, as you know, Rebecca gave us a little preview of that, in energy transition related disputes.
Yeah, thanks, Cherine. So yeah, I'm going to build a little bit off of what Rebecca was talking about in terms of causation. So first off, before I start, answering this question, I want to make sure that people understand what we mean by causation. So causation concerns the question of whether or not the alleged harm would have occurred but for the alleged wrongful act. So in short, we're trying to disentangle the losses caused by the wrongful act and losses that might have been caused by other unrelated factors. So as experts, we are very oftentimes intentionally instructed to just assume causation. Sometimes this is the result of intentional legal strategy, but sometimes, and especially in the more complex cases, and I would definitely put renewable energy disputes in this bucket, sometimes experts are needed to either establish or refute whether the alleged breach was the direct, sole, or primary source of harm. So for experts, causation analysis usually involves two different steps. The first step deals with figuring out whether the alleged breach actually caused the harm. And then second, if it did, we have to figure out, okay, how does that harm translate into the damages? And are we accurately quantifying that harm and the damages? So especially for investment disputes related to state policy and regulation, where a project has or an investment has failed, the first step is important because you have to assess whether those state measures were the operative cause of project failure, as opposed to unrelated market, economic, and operational factors that might have occurred even in the absence of the measures. And then with respect to the second step, and this is where damages experts have traditionally played more of a role, you have to precisely link the claimed damages to the alleged harm. So how do we do that? Well, that's going to require very careful construction of your counterfactual scenario, your but-for scenario. So that scenario has to remove the alleged breach, but also it can't remove any of the exogenous value drivers that would have occurred and would have had the same impact even without the breach. So just to make this a little bit more tangible, I want to give a couple of examples. The first example are the various ISDS cases that have been filed over the phase out of coal-fired power. And some of these have been mentioned already throughout Washington Arbitration Week. They're no doubt familiar to many of you. And these are cases like RWE versus the Netherlands. I think Clara mentioned that. Uniper versus the Netherlands, and Westmoreland versus Canada. So while these cases didn't proceed to damages, having been either withdrawn or in some cases dismissed, it's a very interesting thought experiment as an expert to consider how damages would have been dealt with in that case or in those cases. So in those cases, experts would have likely needed to evaluate the extent to which the mandated coal phase out prematurely destroyed the asset compared to if market forces alone were at work. So this raises very interesting questions for us experts about things like the cost of coal-fired generation as compared to the cost of renewables. So Clara mentioned this earlier in her remarks, but it's considering the fact that, well, now renewable energy is cheaper than running most coal-fired power plants. So when you're thinking about constructing your but-for scenario in one of these examples, you have to account that you have to account for the fact that basically even without the alleged breach, there are going to be some market forces that are causing, that would already tend to shorten the economic lifespan of these assets in question. So that's one example. Another, I think, great example here comes from actually the world of climate litigation here in the US. So this is an area where I think causation is going to be a huge issue. climate-related litigation matters in the US right now are focusing on the alleged failure of fossil fuel companies to disclose climate risks related to emissions, basically the effects of consuming their products. So in these cases, the plaintiffs have endeavored to prove that absent these alleged disclosure failures, the defendants and other industry players would have been able to achieve net zero targets more rapidly, potentially even averting climate disasters. So here again, I think there's going to be so many different layers of causation for experts to unpeel. And that's not just damages experts, that's, you know, industry experts, technical experts, climate scientists, and so forth. So for example, you might have an expert assisting with analyzing how consumer behavior would have changed if fossil fuel companies had disclosed climate risks at the time that the plaintiffs are alleging. Or for example, you might look at whether energy transition would have even been technologically possible or economically feasible at the time that the plaintiffs are suggesting. So I think there's going to be ample room for causation, especially for experts to analyze these issues, especially as the complexity of these claims starts to grow.
If I could just add a comment on that helpful description. The complications should also be recognized when you think about what we're worrying about here: carbon emissions, greenhouse gas emissions. Carbon emissions, a substantial piece of it, but not all of it. You have to think about it economically from a global market perspective, right? So when we had first emissions issues of nitric oxide and sulfur dioxide, those are local. They harm the local environment. But here, a complication in having to show climate disasters starts with what is the impact of reduced carbon in a localized area on a global market, if you will, if you think of it that way. And that presents high challenges to determine from reasonable certainty. And then if you think of it, individual market participants or defendants, well, one company change of a small area impact of a global area impact, it raises questions of what you can show from a statistical reliability. And so all of these cases, which are test cases, really have very challenging expert roles that are very hard to say. And I should say, just it's not just damages experts, but technical experts have to show all of these piece parts for the level of demonstrations that are required for reasonable certainty overall.
Yeah, thank you for adding, Julie, and thank you to Alayna. So we have another set of questions, but I'm going to play the mean role of timekeeper and ask you to please keep the responses to around 3 or 4 minutes so that we have enough time to get to the last part of the discussion. So let's come back to you, Julie. As you regularly testify or provide expert analysis in international arbitrations, which involve emerging technologies and CO2 offset credits, can you provide some context as to the economic factors and analyses that are required in those types of disputes?
Yeah, I'll be quicker to help us save time for the group. So from a CO2 offset, the shorthand carbon dioxide offset credits it has to do with the regulatory regimes that are seeking to reduce the carbon from the atmosphere, and so they are localized. They are for localized market participants, and oftentimes they are setting a price on carbon. Now, that provides a regulatory compliance opportunity for not just market participants who are emitting to have to pay, but for new market participants who can find ways to remove carbon out of the air, a new technology, carbon capture and storage as an example, but lots of others, to be able to have a tradable product a tradable commodity, a different commodity. So they're evolved out of the regulations to reduce carbon and setting, using prices as a tool, as an economic incentive for these new technologies to come in and to be helpful. And so those who have to comply as the emitters may be leaning on those who are able to pull carbon out of the air to meet compliance. And there's a growing tradable market and activity by businesses to gain these royalty agreements, and their business is growing up from that. And they can include a wide array of technologies. Each technology has its own profile, has its own challenges. We're talking about how much emissions can be removed. And so there's a question in terms of reliability, what those emissions are. Those profiles need to be evaluated. If there was agreements among the parties of a certain level, were they able to achieve it? But technology by technology varies. Understanding the rules of the road of the regulatory regime, what are the economic value needs to be done, and it can be complicated. And as things are evolving, that the expectations can change. All of the political risks and changes that, even if they're small changes, can have impacts too. So you can think of it as much more complicated than the renewables. And then understanding and thinking about it from the specific asset and the opportunities for that asset in a uniquely positioned market for buyers and sellers.
Alayna, today we're seeing a growing number of commercial arbitrations which are tied to issues such as construction risk, offtake contracts, climate-related obligations, amongst others. What are some of the key drivers amongst commercial arbitrations or litigations that you've seen, which involve renewable energy or climate change, and how are you seeing them, or how are you expecting them to evolve as the energy transition accelerates?
Yeah, definitely. That's a great question. And I know you touched a little bit on commercial arbitration as well. I know Washington is the home of investor state arbitration, but I wanted to bring commercial arbitration into the conversation as well. So I'll try to keep this short. Clara did a great job already of talking about sort of the different types of ISDS. So let me talk about drivers of commercial. So first I want to actually go back to a study in 2019 published by the ICC, and it was about climate change related disputes. And they predicted that climate change related disputes would increase exponentially. And they said particularly commercial disputes brought about by businesses as they adjust to increasing regulation of emissions. So these disputes were forecasted to be in the context of asset divestment, renewable energy investments, and carbon trading and pricing, as we've already kind of heard Julie discussing. So in terms of what's driving this wave of commercial cases, I think based on my experience, I can definitely point to several general trends and a common set of catalysts. So I'll just touch on three, and this is by no means an exhaustive list, but it's what I've observed. So the first one is pricing volatility. I think energy price swings are one of the leading drivers of commercial disputes. And this tends to happen particularly when spot prices diverge sharply and for a sustained period of time from contract prices. So that can incentivize some very interesting behavior in terms of perhaps it incentivizes defaults or non-delivery. It might incentivize renegotiation of the price under the contract. So I've seen this several times in the context of gas and LNG contracts over the last several years. But I think it also equally applies to renewable energy. So you can just think of an example, for instance, if the market price of a solar panel goes up, that could change the incentive under a fixed price module agreement between a buyer and a seller. So I think these are very typical types of disputes that you're going to continue to see more of in the context of pricing volatility. The second one I'll just touch on briefly because this one tends to be the most familiar. I think for people, these are construction delays and supply chain disruptions. So of course, building and operating renewable energy projects can be technically complex. Project-related disputes are common. And these projects involve just numerous contracts. They have engineering, procurement, and construction contracts, offtake agreements, perhaps even project financing agreements. So here you have that obvious source of disputes from delays and cost overruns, from global supply chain issues, and essentially from failing to deliver equipment on time and at the agreed price. So that's bucket number 2. Moving quickly to bucket 3, I would call this market structural change. So I think the push to decarbonize is causing some structural shifts in markets. And that's either stranding assets or it's prompting premature contract termination, which tends to end up in disputes. So as countries integrate more renewables into their energy landscape, I think some long-term gas or coal supply contracts between private companies may become more onerous, potentially leading to arbitration. So for example, if you have a utility with a 20-year gas contract, you may find that surging solar and wind output cuts your gas needs. So you might seek to terminate or renegotiate that contract. Or if you're an LNG importer and you end up oversupplied because renewables grew faster at a rate that's faster than what you expected, then you could potentially have a dispute arising out of hardship or force majeure. So I think what's really interesting here is that it's kind of that intersection between shifting from old sources of energy to renewables and the tension that can sometimes create when you have a structural shift like that, that's becoming a big driver of renewable energy disputes.
Yeah, thank you so much. Fascinating. So one last question for Rebecca, and then we're gonna shift gears to wrap up the panel. For Rebecca, what role does industry-specific knowledge play in your work? I know a number of the experts here on this panel do valuation, but also act as technical or industry experts. And how do you stay current with evolving technologies and renewable disputes? How do damages experts collaborate with counsel and arbitrators in navigating these technical aspects of renewable energy disputes?
Okay, so short answer, the industry knowledge just gives you credibility, right? Like, while you learn some while you're on the job and alongside working with the industry experts, to be a credible expert, a damages expert needs to have an understanding of the industry, and more importantly, needs to relay that to the tribunal. So having that knowledge would help the damages expert develop a more sound analysis of losses, especially in a sector like renewables, where there's a lot of innovation, complex regulations, and the market is constantly evolving. So with that industry knowledge, you can contextualize the investment easier, right? Like you need to have an understanding of the technology, again, like solar, wind, or hydro, to assess realistic performance expectations. And you need to understand the development cycles of the project, because that would affect the timing and amount of losses, as I mentioned earlier. So the combination of those two then kind of lead into selecting the methodology. For example, if you value a solar project with a 20-year PPA, the analysis is going to differ significantly than a wind farm that's exposed to spot market prices. So the expert also needs to be familiar with the renewable energy policy frameworks, and they need to know how to interpret specific policy shifts, such as subsidy cuts and grid access restrictions, because those are going to impact the revenue streams and the risk profile of the project. Again, just working with the industry expert, like make sure you carry that whatever you learn from the industry expert, like carry that even from one project to another. Because when you're testifying, your job is to make it easy for the tribunal. So if you demonstrate that you're fluent and comfortable with industry terminology, standards, and trends, then you'll seem more credible and be more persuasive to the tribunal. So with that said, to stay current on all these technologies, especially in this industry, there's a few things that people can do. They can attend industry conferences or workshops, read technical publications, reports, journals. There's a lot out there that you can find. Take advantage of professional networks. One thing that I actually do when I'm working on a new renewable is I'll go back and look at awards that have been made public recently, and I'll see like what arguments were put forth by both parties and then what the tribunals decided. So I found that really helpful to kind of just stay current on what the decisions are. As far as working with counsel, I see the damages expert as like the bridge between the technical and industry expert to the legal strategy of the case, right? So early on, a damages expert can help the legal team and by reviewing documents, reports, contracts, and identifying issues that can support or challenge some of the claims. So this would help the legal team evaluate the viability of the claims and come up with a sound legal strategy. So you can kind of work together from the very beginning of the project. And then with arbitrators, as I said earlier, it's kind of, it's our job to educate them. So we need to translate things that are highly technical into like plain English, and not all arbitrators have the technical background. So we need to make it easy for them to understand the important points of the case. So when a damages expert submits an expert report, it needs to be easy to follow, but yet detailed enough that the tribunal can dig into any particular aspect that they are specifically interested in, right? So make sure all the assumptions are laid out, and even provide sensitivity analyses so that the tribunal can see how one specific factor affects your overall result. And then take advantage of your oral testimony to make sure that things are coming across the way you intended them to. Using visuals can be helpful during testimony. What else? I guess tribunals, sometimes they will ask for a joint expert report after the hearing. So at that point, the opposing experts need to get together and kind of come up with, identify areas of agreement and disagreement. And again, it's to make it easy for the tribunal, right? Like lay it out very as simply as you can so that the tribunal can see both sides and make a decision. So aside from like the financial and technical aspects that an expert needs to master, they also need to master certain like, soft skills like communication, coming across credible, impartial, and just make sure that everything you say is strategically aligned with the legal aspects of the case, like the legal strategy of the case.
Thank you so much. So I know we have about 5 minutes left on the panel. We did start a little bit late, but we have several other events taking place today, so I don't want to take up too much time. The last subject that we wanted to address on this panel was, in fact, the issue of gender diversity and the increased either greater opportunities or increased obstacles for gender diversity in this context of renewable energy disputes. Are we seeing more experts that are women appearing in these disputes or as testifying experts or on expert teams? Are we seeing more counsel who have that industry knowledge and that familiarity? Are we seeing people who are familiar with the various litigation and trends and regulation across the world or in particular jurisdictions? And is that creating greater opportunities for diversity or hindering in any respect what's available? I know we had a lot more planned for this part, but given time, if you could each person just take 1 minute to give some brief thoughts on this, and then we'll open it up to maybe 1 or 2 questions from the audience, and of course we can discuss further after the panel. Julie, can we start?
Sure. I think new and emerging areas is definitely worth considering finding a specialty, not to the exclusion of other work, but you are able to stand out when you can understand things deeply. So if you don't understand it, but at a high level, you may not master it relative to other alternatives that are available for selection. And since it's new and emerging, that means there are less people who can say, yes, I did this 20 times. So you immediately have an advantage. It is one thing that I did earlier in my career. I started following solar, wind and other kinds of cases and getting the expertise well before it became mainstream. So finding one of the emerging technologies that is of interest to you, that you're passionate, you're willing to invest yourself as part of your portfolio, I recommend, and it was something that I did on my own.
Alayna?
Yeah, I mean, I think when I think about establishing yourself as an expert within renewable energy disputes, I think it's kind of the same for if you're trying to establish yourself as an expert for any dispute. I think one of the biggest factors is visibility in terms of gaining traction as an appointed expert. That can take a lot of different forms. I think at its most baseline level, it means that you're visible to instructing lawyers, both on the casework that you're servicing, but also in the broader industry. So, doing publications, speaking at industry conferences, getting involved in the professional organizations like the ERE, some of the ones that we've already talked about. So I do think that visibility, though, can be greatly enhanced when, emerging experts can form a partnership or a mentorship with more established experts, whether male or female. I think, looking for those established experts who are willing to provide mentorship, who are willing to advocate for you internally within your organization, externally in front of clients or potential clients. And, that might be as simple as having your name listed as a potential expert on a client proposal, or it might be as far as having your name listed as a co-expert on a submitted report with the potential for co-testimony. So I've seen all of these avenues work for people in terms of helping establish themselves in the field, and particularly for women.
Thank you. Rebecca?
Okay, so I had all this data I was gonna share, but I won't.
If you want to give the high point.
Yeah, I'll just go high level. So the ERE that we've mentioned, there's a survey that they conduct. It was conducted in both 2023 and 2024 to kind of track the progression that women have made as far as participating as arbitrators and experts. Actually, more specifically, experts. The ERE is focused on experts. And so while things have gotten better, it's slow. It's a slow progression, and there still are like several obstacles for females to be highly visible in the industry. But the survey showed that based on the survey's responses, which were mainly experts themselves, they said that they had been appointed or had testified as a sole expert in about 10 of their cases. And there's the most reported reason for that they felt was that lawyers and clients tend to opt for experts that already have experience giving testimony. So it's hard for a newcomer to come in and like establish themselves. But then on the positive side, it's like once you get that one, then it's easier to get more and more. So when we asked in the survey who has been appointed 20 times or more, it went up from 32% to 36% in just that 1 year. Now, again, this is limited to the survey respondents, but it's something. And their solution for that was what Alayna was saying about visibility, like just getting out there with the instructing lawyers, even within your own organization. And then another study that I looked at is a damages study that we published at HKA, where we focus on awards for publicly available awards for investor state cases. And after tailoring down the data set of almost 800 cases, for various reasons, it's tailored down, and we have 85 renewable cases in the data set. Only 6 of those cases have damages experts have females as damages experts. 22 of them had 1 female arbitrator, and 3 had 2 females on the panel. When you look at the legal team, because the legal team is a lot bigger, there were 66 out of the 85 cases that had females listed on their legal team. But the caveat to that is that we don't really know what their role is within the legal team, right? So, you know, and these numbers have been trending upward in the last few years. But there still is a lot to go. So we just need to keep at it, get ourselves out there and accept that it's not going to happen overnight, but don't give up.
Yeah, and one challenge we've seen both on as far as appointing female arbitrators and increasing female representation as members of council teams, and I'm sure Clara can talk about this as well from the former council perspective, is, you know, trying to conceive of experience in a more fluid way. And we've seen a lot of arbitral institutions actually doing that, rather than looking for someone who has already served as an arbitrator. Perhaps they can demonstrate that experience through different means. Maybe they have done a lot of speaking engagements. Maybe they have done like very close client work on a particular topic. Maybe they have publications that demonstrate their industry knowledge. Obviously, you're looking for the best candidate that has the best experience and understanding of the dispute and would get the best results. So it's you know, it's not all or nothing. But we've seen a lot of success of arbitral institutions in particular looking at diversity in a more fluid way to provide those first opportunities. And I think that's something that could translate also to the expert appointment process, where you might not have testifying experience, but you might have been that, like, you know, right-hand person to the testifying expert, have witnessed that and perhaps demonstrate your experience in other ways.
Let me apologize to everyone here, and especially to you, Clara, because you were just about to take the floor. We have another